Hi, this is Alan Gassman. Welcome to This Morning, Tuesday, May 19th. I'm here with my good friends, Brandon Ketron and Kevin Cameron. We've learned how smart Kevin Cameron is. Holy smokes, you're gonna wait till you see what he's done. And we're gonna talk about something that the three of us spent most of our time on this weekend and yesterday, as a matter of fact, and that is the new release of the forgiveness application and instructions. And in 28 lightning bolt minutes, we're going to take you through just about everything you really need to know about this. Most of you don't know Kevin yet. Kevin is a practicing CPA. He has a really nice practice in Tampa, Florida. Kevin and I have known each other for about 30 years. He has spent a lot of time and had a lot of people in his firm helping him prepare the analyzer we're going to talk about. We're really, really enthusiastic about it. Please send us questions today. You've got our email addresses here. We have a for pay presentation at 3 o'clock to 4:30. And if you send us questions, we'll go ahead and answer them for you. And we'll probably also incorporate them into our 4:30 webinar. Brandon, can you go to the next slide, please?
Yeah.
Okay, Wednesday, we're going to do 15 minutes on what's going on for medical practices in the loan world. So feel free to join us. That's for free. Next, Brandon. Then we have, sorry about that. Brandon and John are going to talk about real estate tax planning for both people who are wealthy and people who might lose it all on Thursday. And then for pay, we're going to talk for Lissy with Kevin about his new PPP spreadsheet and repayment calculator and document tracker system, which Brandon and I have spent some time on and really like. John and Brandon and I are, and Chris and I are going to talk about IRAs and retirement plans. There's a great replay of what Ken did Saturday on cornflakes and estate planning mistakes available. And this Saturday, he's going to talk about T for 2 and 2 for TPE, which is also a very interesting topic. And there's more to join us with. So thanks for all your support. And thanks to Jerry Hesh, we are going to have the Notre Dame Tax Institute, whether it's live or on the internet, October 29th to 30. If you've never attended, just look at these topics and you can pick each hour which topic you want. And doing it from home on the internet would be a very, very effective and excellent program. We've got a table of contents here and some numbers on page 17. Apparently, there's over $100 billion still remaining in Paycheck Protection Program funds. I think a lot of this are independent contractors who have not done their Schedule C yet, but a lot of it is medium-sized clients and large clients. So if you have clients that still haven't filled out their application, they may just fly through. Page 18, I want to give you a very brief review of the main takeaways from this weekend. Number one, the rules are fairly taxpayer advantageous, and there may be clarifications later that are less advantageous. So I would like to get this application filed immediately after the applicable 8-week period. So I would dive into this before the rules get worse. Number two, it is now no longer a strict 8-week period. If your normal payroll cycle starts after the day that follows the day you received your PPP money, your first money, then you can wait and start the 8 weeks for payroll, healthcare, and pension purposes when your next payroll cycle starts. That doesn't apply to rent or interest or utilities, though. They'll still be for that first 56 days. Again, we're going to cover all of this later. Number three, there's nothing in this application about the necessity requirement other than that the borrower must reaffirm that everything they've done in the past is true and accurate. So that would include the necessity statement. We have slides on the necessity statement, but let us just say, even if the loan is under $2 million, SBA simply says that they will not investigate necessity and they will not refer necessity issues to the Department of Justice. That doesn't mean that a whistleblower or the Department of Justice or possibly even the IRS might come in and assert that there was no necessity. So necessity is still vitally important. Number 4, your retirement plan contribution may not have to be prorated to the 8 weeks. It might be for all of 2019, for all of 2020. This may be the silver bullet for a lot of applicants. It seems to be a gaping loophole. Some commentators are saying don't take it. I say think about making the deposit now and then waiting to see what the rules are up through the day that you file your application. Number 5, it may be possible to prepay rent. Wait and don't pay your rent until you get the funds from PPP, then pay the rent in arrears and for the 8 weeks. That might help some people if it's not too good to be true. Number 6, think about rehiring enough people by June 30 to not have your forgiveness reduced. It doesn't look like it does you any good to have them hired before June 30 if that's outside of the 8 weeks. We'll talk about that. Number 7, there's a new rounding technique you can use where anybody full-time gets a 1 and anyone under half-time gets a 0.5. So if you're a fast food store and you've got a bunch of high school students working 12 hours, 14 hours a week each, this may work well. That's number 7. Number 8, your payroll costs may be counted if incurred before the 8-week period. You may be able to late pay your payroll costs and get more than 8 weeks of payroll costs in when you read these instructions literally. Number 9, the 75% test is not an all or nothing cliff. If you don't spend 75% on payroll, health insurance, and pension, you still will get to forgive those expenses, but your utility, rent, and interest expenses will have to be reduced in proportion. And number 10, what Kevin has shown us is you really have to run the numbers on this. Until you run the numbers and until you show the client the numbers and what their alternatives are as to who they bring back, when they bring them back, who they reduce, whether they reduce it, you really don't have the understanding. So that's where Kevin's analyzer is so valuable. So SBA FAQ 46, May 13, 2020. If you've borrowed less than $2 million, you will be deemed to have made the required certification in good faith. So the SBA gives you a pass, but like I said before, the Department of Justice may not give you a pass. We've spoken on the necessity requirement in the past. You have until May 18th. What's today, Brandon?
Yeah, today's the 19th, so the date is passed.
19th. Okay, so you can't backdate this. Too late, don't worry about it, but document your necessity as best you can. And if you decide that part of this loan was not necessary to support the ongoing operations of your business through the virus crisis, through the recession expected to follow the virus crisis, then give some of the money back. If you give it back, you may be able to take the credit for employers, but maybe not because you didn't give it back soon enough. We'll wait and see whether they extend that. There's a Forbes article that we wrote on the under $2 million issue, and you're welcome to read it or go to Forbes and click on it or search Gassman Forbes PPP. You can amend your PPP application if the entity was a partnership and you did not include partner compensation, also known as guaranteed payments, or if you're seasonal and you could have gotten more based upon the guidelines. But if you amend your PPP application and get the money and it's after the 8 weeks, then you may just have to pay it back because there's no mechanism to give you more than 8 weeks from when you get your first dollar. So that's interesting, something you can write your congressman about. And Brandon, what do we have here on page 33?
Yeah, this is just more about that the extension or the ability to amend your application for partnerships. You're eligible to do this until the lender has filed this form 1502. So if you're in this situation, reach out to that lender right now and tell them, don't file this form. I'm thinking about amending my application to get these additional amounts. So it's important that we reach out to them sooner rather than later, because once this is filed, you cannot later amend your application.
So you have to do this before the lender files the form SBA Form 1502. So if you didn't include a partner in the payroll of your PPP application, or you have a seasonal issue, email your lender and say, don't submit my SBA Form 1502. Watch this crazy webinar and see why. Here on page 38 is Brandon's chart of the PPP rules. I think everyone on this call knows in general what they are, but if you don't, page 38 is a good place to start. And where should we start, Brandon, to talk about, oh, by the way, for all of you watching, the rules are different for independent contractors and sole proprietors. You can't get credit for your healthcare expenses or your retirement contributions or your state taxes imposed on payroll. And this also, according to these new application and instructions, this also applies to partners in a partnership. Unfair, and it was a little bit unclear before, but they put the nail in that coffin. If you were an S corporation or a C corporation, you're good as gold for these things. If you're an independent contractor, sole proprietor, or you were filing as a partnership under a 1065, you're just out of luck. And there's no rhyme or reason as to how or why that is the case.
Just a moment, I didn't catch that.
Oh, and even
Could you try
Siri's
again?
listening to me. Sorry about that. All right, Brandon, do you want to take over here and tell us what we learned?
So this is a new ability to count payroll costs during that 8-week period. They're not strictly enforcing this paid and incurred standard that was in the statute. What they have provided that if you are measuring your payroll cost and you're applying for your forgiveness and your 8-week period has ended, but you haven't yet paid that last payroll, as long as you pay it on or before that next regular payroll date, as long as what was incurred during the 8 weeks, you can count what was incurred even though it's paid afterwards. So it's not a strict test anymore. One thing that was mentioned is there's no further relief provided for extending the start date of this 8-week period other than the 2 exceptions that we're going to mention. So there's no mention of extending it until when the business might be back up and running again, like a lot of people were hoping they would come up with. So it's strictly on the date you receive your loan amount, starts the 8-week period, but there's 2 alternatives that we can use. One of these being that if the payroll costs were incurred during the 8 weeks, you can still count them as long as you pay them by that next regular payroll date. And this is the language here from the application where this comes from. Now there's a second test here, or a second period, and it's called the alternative payroll covered period. And you're eligible for this if you pay payroll biweekly or more frequently. So if you're on a monthly basis, not eligible for this alternative period. But what the alternative payroll covered period does is delays the start date of that 8-week period until the first pay period following the date that you received the loan funds. So if you were in the situation where you got your loan funds in the middle of a pay period, you can wait to start that 8-week period until the next week. So it lines up perfectly with your pay periods, which was a nice exception to those strict rules that the SBA provided in this application. Now the catch here is that this only applies for your payroll cost. So you're counting your health insurance, retirement plan contributions, state and local taxes using this alternative period. But for your interest, rent, utilities, and those other non-payroll expenses, you're still in the traditional 8-week period starting on the date you receive the funds and 56 days after that. So there's 2 tracks that you have to measure here, one for payroll and one for non-payroll if you're using this alternative period. So we have the language here from the application that discusses this in more detail, highlighted here on slide 47. Now on retirement plan contributions, the application didn't specifically mention anything about retirement plan contributions, but I think one thing to point out here is that when they define payroll costs and what payroll costs are included, it says payroll costs incurred or paid during the covered period or the alternative payroll covered period. So reading that means that if you pay a retirement plan contribution during the covered period, it should count, even though it might have been incurred in 2019 or attributable to 2019 pension plan contributions. It seems to us that if you pay it in this covered period, that it should count. Now, whether it's going to be prorated or not, we don't know that yet, but at least we know that I think we can count a portion of 2019 and probably a portion of 2020 as a retirement plan contribution during this covered period. There's also no mention of whether it has to be a qualified plan or not. So the jury's still out on that issue, but it seems to us that you might be able to include top-up plans or rabbi trusts or other similar retirement plans that aren't necessarily qualified plans under the tax code.
So one of the commentators said that he read on the internet that you could do this, and he strongly recommended against it. We think that if the cash flow is there, and considering that the client can borrow what they put in back out if they qualify under the new CARES Act, that it makes sense to do this now and decide later or disclose on the application. I'm assuming that I could write off my entire pension plan contribution or forgive it. That's what I've done. If I'm incorrect, please let me know. I don't see that the government's going to be able to punish somebody for doing that, especially given this exact language where they've made very clear that for payroll and other things, I mean, for other items such as the payroll, it has to be paid and incurred. But here they didn't say that. They used the word or.
Great.
And I like to quote Learned Hand there on page 49. Anyone can arrange his affairs that his taxes shall be as low as possible, not bound to choose that pattern which would best pay the Treasury. There is not even a patriotic duty to increase someone's taxes. So I would think the same applies for this program. If you're honestly applying the program, if the loan was necessary, if you can borrow from your pension plan, this can be a good combination.
Yep. Yeah, and this is the language here from the application where we, came to this conclusion. Notice it says incurred or paid, not and paid. So they seem to be providing some flexibility here on these costs and expenses. Now, of course, the SBA may prevent this with future guidance. We're still waiting on official regulations on loan forgiveness. They've just released this application. We have slides here on what you can contribute to these retirement plans based upon maximum compensation during the year. So all that is available. And it's important to also point out that these retirement plan contributions and health expenses are not subject to that $100,000 cap. So there's really no limit on what can be counted until the SBA might come back and limit that for us.
By the way, the titles in blue are what we've learned since the application came out. The titles in red and blue are for independent contractors and proprietors. So if you want to just fly through this deck later on your own and look for blue, that covers the application and the instructions.
Yep. So another issue here that we have come up with from the application itself is whether or not these retirement plan contributions can count for independent contractors or proprietors or even partners in a partnership. And we're struggling to find where that they can count for these individuals, whether that's the intent of Congress or not, we don't know. But based upon the application, they're just listing that you have to include contributions for employee health insurance, employee retirement plans, and state and local taxes assessed on employee compensation. Now we know partners in partnerships aren't considered to be employees, but if you're in a C corporation or an S corporation and you're the shareholder, you can still be a W-2 employee. So those entities can count these contributions if you're under an S or a C corporation. Sole proprietor, independent contractor, partner, you're not considered an employee, so it doesn't appear that you can count these contributions, so you're limited to this owner compensation replacement of a $15,385 max based upon the $100,000 maximum. So these types of entities are going to struggle to get the full forgiveness by not being able to count for these costs, and are really treated unfairly compared to other types of entities. So hopefully this would be corrected through guidance, but as of right now, these are the rules. And we have the slides here where this come from. Notice it's employee health insurance, employee retirement plans, and then there's separate line items for owners of self-employed individuals or general partners, which is subject to that $100,000 cap.
Brandon, let's say that before the 8 weeks, I'm a partner in a partnership. We got our loan. I've had to lay people off. And before the 8 weeks starts, I convey my partnership interest to an S corporation and I become an employee of the partnership. I don't have to have a guaranteed payment. Now I'm an employee. So now during the 8 weeks, can my health insurance and my retirement plan contribution count towards forgiveness?
Yeah, that's a possibility. I don't know. I'm trying to recall if there's any rules that would prevent, the change of the ownership structure that might cause an issue, or anything like that. But that's certainly an idea that we can dig into and see if that would work. But I think off the top of my head, just best guess, I think that would be a potential planning idea that would work.
Excellent.
So moving forward now, as we mentioned, similar to payroll costs, if you pay something or if you incur something during the 8 weeks, but then pay it afterwards in the normal course of your business, whether that's at the next pay period or the next billing date, you can count those costs. So specifically here, the instructions provide that a non-payroll cost must be paid during the covered period. Okay. So that seems like you might be able to count prepayments of something because you're just paying it during the covered period. Because then notice the or incurred during the covered period and paid on or before the next regular billing date, even if that date is after the covered period. So as I mentioned, prepayments might count. For these, there is one specific item where prepayments may not count. And we'll talk about that here in some subsequent slides. But here is the language on these eligible non-payroll costs. Remember, we still have that 25% limitation that can apply. And then specifically here on slide 64, we have this mention of business mortgage interest payments, but we cannot include prepayments for that. But then there's no prohibition when it goes to the instructions for the line items for rent or lease payments or utilities or any of the other non-payroll expenses. It does not include this, do not include prepayments. So we don't know if that was intended or an oversight, or if you're actually thinking that if you pay these in the 8 weeks, that you would get credit for them towards your forgiveness. Now remember, we can't prepay a lot because we have the 25% limitation. Go ahead, Alan.
Kevin, what are your thoughts on all this, and what are you telling your clients about rent, interest, and utility payments, and when do you think they need to make them by?
Yeah, Alan, that's a great question. And right now we're pretty much still sticking to the line of proration or focus strictly on what is incurred in that 8 week period and paid maybe after the 8 week period. But we feel like the SBA is really struggling with this paid and incurred language, excuse me, and they've kind of fouled it up in their drafting of these instructions. We feel like they're going to be sending out quite a few FAQs or other guidance telling us that's not what they really meant. And there's certain places in the instructions where there's an and then there's certain places where there's an or. So it even provides some further confusion. So presently we're telling people keep track of the expenses, and the tracker does that for the specific period and still prorate, but keep off to the side these other optional items such as a prepayment of rent or the payment of a retirement plan contribution that's accrued but not paid yet, say even for the prior year. I think we're all in the status of start tracking what we can now, but kind of hold tight and have almost like a optional tracker of additional expenses that you might be able to add. And I think that's why paying attention to your specific 8 week period is incredibly important. I believe that's, we all file tax returns based on our tax year, and most of us are calendar years. And so everybody knows what they've got to do by December 31st in their normal tax planning. But in this case, your 8 week period might end on a Tuesday or a Sunday. And so you've got to really pay attention to these dates.
Thanks, Kevin. And Kevin, I guess it can't hurt to not pay rent until the 8 weeks starts, pay it during the 8 weeks and hope that the SBA is okay with that, right?
As long as your landlord's okay with it.
Right.
But Alan, and to that point, I have dozens of clients who were able to secure rent deferrals, rent abatements, even some forgiveness. A couple of situations where rent leases have been extended. And so we have a lot of borrowers who aren't paying rent right now. They probably need to go back to the landlord and renegotiate that agreement to pay the rent for this applicable period. and then push off the deferral, abatement, or other arrangement they made into July or August, or even further down the road.
Kevin, let me ask you another question before we leave this. When I buy a car, I call it I buy a car, but you know, you lease a car on a 36-month lease or a 60-month lease, or you lease a piece of equipment with a $1 buyout. So I think most of the lawyers on this call don't really realize how you book that for tax purposes. And how would you treat that? Is it interest on a loan, or is it rent? What are your feelings on that?
That's a great question too. You know, we've got different accounting treatment for these leases that are commonly referred to as capital leases or asset leases, where the lease is treated as a financing contract for both accounting sometimes and tax purposes. And those are treated as loans, but I believe that's strictly accounting or tax treatment. I don't think that in this case with the SBA, if I've got a regular vehicle lease or I lease a fleet of vehicles, whether I've capitalized them as an asset and with a corresponding liability, the underlying contract or agreement I have is a lease, and that's determined as a rental payment. Even though the accounting treatment may be different, the actual contract or agreement is a lease and not a financing contract. So I believe that if you've got a borrower who has vehicle leases or other types of capital leases, they probably are okay counting these lease payments as lease payments under the current guidance we have.
And then one more question I had for you. What are you telling clients transportation means? And what are you willing to put down on the application and not lose too much sleep that this is what they thought was meant by transportation?
You know, that's a great question. And right now, all we're really telling people is fuel related to your company vehicles or any type of transportation vehicles you have for your business. Go ahead and count that for right now. I don't know if the intention was that you can include the cost of transporting the utility itself. Is that what transportation meant, or did it mean physical transportation costs, which wouldn't make any sense because transportation costs are generally not a utility under any definition I'm aware of.
Yeah, okay. It just seems like the word transportation got in there by accident, but it has to have a meaning. That's the way you're supposed to interpret the law. So,
well, Alan, if you've got a company that owns a chain of restaurants and they deliver natural gas to their different locations, they're going to incur a transportation cost for that.
I see. That may be what it was intended.
Yeah.
Okay, Brandon, carry on.
Yep. Okay, so as I mentioned, you know, we have this prepayment limitation here, but not for lease payments or utility payments. So, you know, I don't know if that was intended or if we're just reading too much into the application or not. As Alan mentioned, we can not only count, you know, interest on real estate as mortgage, but also interest on auto loans for vehicles we use, interest on equipment that's collateralized. So I think rent is also, you might think traditionally this might just be real estate rent, but we're also looking at equipment as well and any leases that you have. So it's a little more broad than we might have initially thought. Same thing with utilities.
And maybe common area expenses as well, and other things that you pay with your lease. How about sales tax on rent? Is that rent? It seems like it's kind of like rent, so not sure. Who knows?
Yep. So all these are, you know, slides here that we have, and they specifically mention as utility payments, rent or gas you use driving your business vehicle. That was in the independent contractor regulation. So it seems like they might be talking about transportation for, you know, gas that you actually use maybe to get as part of your business, but we'll see if they further limit that. We have information here on what you're required to be keeping track of, what documents you're going to have to submit with this application. So take a look at these slides and go ahead and start pulling these things together now so that way we're ready at the end of our 8-week period to submit all these with the application. So I think these rules here on the reduction of forgiveness has slightly changed since the release of the application. we know that step one, we're going to count all of our expenses incurred during the 8-week period following the disbursement of the loan, whether that's using the alternative payroll calculations or not. We have to measure those expenses first. So then, according to the application, what we do is we look at our number of full-time equivalent employees during that 8 weeks compared to the prior period, and reduce the loan for that. We also have to reduce the amount of forgiveness if we reduce compensation by more than 25%. And then we have a loan forgiveness total going through those steps 1 through 3. You take that number and compare it to this payroll cost limitation where you have to use 75% towards payroll cost. The application does that by dividing our payroll cost by 0.75. So then we could get our maximum loan forgiveness, assuming that we have this 75-25 ratio. Then it says we compare the amounts in step 1 to 3 to the amounts in step 4 and take the lesser amount. I don't know if this is a drafting error in the application, because that could allow us to include more than 25% of non-payroll costs, because this reduction here of steps 1 through 3 could, is not subject to that 25% limitation, since we're using the lesser of here. Kevin, I know you pointed this out as well. Do you have any additional thoughts on this item?
Right now, Brandon, I think that it is maybe a drafting error in the form. I'm not sure, or if they're just going to say that if you take your qualified payroll costs and divide it by 0.75, that is one of the limitations on the loan forgiveness, and to the heck with your other related costs. I think the 25%, we got to remember the 75% and 25% are rules the SBA has created. The CARES Act never mentions these percentages. So we probably even have grounds for saying that if it does exceed 25% of the total, you're still okay, because the ultimate forgiveness is really based on those 3 criteria, which is the modified total, if you have an FTE limitation, or the actual PPP loan amount, or the payroll cost divided by 0.75. And nowhere in there does it say anything about the forgiveness being limited or the 25% kicking in or anything of that nature. So I think we'll have to see if they modify that. I think that's something to really, I've run several iterations of calculations, and I can do one where those costs exceed 25% of the loan forgiveness, and the math still works and the forgiveness still works. So we'll have to see how that works out.
Yep, good points. And here we have the application where they're applying these tests. We have our modified total, which is the issue with the full-time equivalent employees and salary and hourly wage reduction. So you take that total, compare it to your loan amount, because our forgiveness can't exceed the loan amount, and then we also compare it to the 75% requirement. We have more information here on the 75% rule, how it actually works, how you apply it. The issue for independent contractors is if they are limited to do this owner compensation replacement, they're automatically going to fail the 75% test. We have the maximum loan of $20,833. If you divide the owner compensation replacement by the 0.75, our max loan forgiveness is $20,513. Leaves around $320 that these independent contractor sole proprietors are going to have to repay, even if they spend all the funds that they've borrowed. Okay, so then the average full-time equivalent employees, we have guidance on how this works now. We take our average number of hours paid per week and we divide that by 40. So we're looking at full-time 40-hour employees, and we can round the number to the nearest tenth. We're capped for 1 full-time equivalent for each employee. So if someone works 80 hours, you can't count them as 2 employees. You just get 1 credit for them. We're also have this simplified method, which basically says if you have anyone that works 40 hours or more, you get 1 for them. If they work fewer hours than 40, you get 0.5. So this could work well for someone that has a lot of part-time employees. They can essentially round up and get a higher full-time equivalent number. So we need to look at these calculations and see which method would work best for you. Now, it's unclear here whether we count owners as employees for purposes of this calculation. And this comes from the issue here on the application where we're taking this Schedule A Table 1 for calculating our full-time equivalents, as well as Table 2. Table 1 is employees under $100,000 of annual compensation. Table 2 are those over $100,000, and then there's a separate line item for our owners. So there's nowhere to enter our average full-time equivalent calculations for our owners. We don't know if you just add the owner in as a full-time equivalent employee, or if you have to just not count them. I know, Kevin, you pointed this out, so any additional thoughts on that item?
The only thing there, Brandon, I believe, is that if you don't count the owner as an FTE in the forgiveness calculation, you certainly won't count them in your reference period. The 3 or 4 different, well, multiple reference periods, but the 2 main ones. So I believe that either it was a mistake on their part, or you don't count them both places. You can't count them in the reference period and not count them in the forgiveness period. That would be unreasonable. So until they give us some clarification on that, our advice to people is just don't count the FTE for the owners in any computation.
Yeah.
So that hurts you a little bit because you have one less body in the numerator.
Yeah, well, it can actually hurt you because of just by math. So yeah, you do have to be a little bit careful with that, and we'll just have to see how that plays out.
I guess it wouldn't apply if you add the owner's spouse as an employee if they've been working anyway, maybe to make up for it. But it seems to me I would want to err on the side of the borrower and count them on the top and the bottom of the fraction. So we'll have to give that more thought.
Yes, indeed.
So a couple of new items in the application as well is we had the good faith written offer to rehire, which the employee rejected. That came out through guidance from the SBA and frequently asked questions, but they've also added the second exception for counting the number of employees, where if we have an employee that was fired for cause, whether they voluntarily resigned or voluntarily requested to receive a reduction of their hours, you're not going to be penalized for those types of employees. So if we have this situation, make sure we have documentation to support this and keep it in our records, so then you can include them as essentially being there when you're doing these full-time equivalent calculations for purposes of reducing your loan forgiveness amount. Now, they also gave us guidance on how we're calculating the rehire section, where if you hire someone back by June 30, then you're not penalized for this reduction of your number of full-time equivalents. So we first have to have the reduction between February 15th and April 26th, and then restore the full-time equivalent levels by not later than June 30th to its prior period that included February 15th. So if we bring back everyone before the virus by June 30th, have the same number as we did on February 15th that we do on June 30th, we're not going to be penalized for loan forgiveness reduction.
So what if you hire 10 people at minimum wage to come and repaint your building, re-asphalt your driveway, work on your employee manuals, answer the phone, throw away old documents, and they work June 30 through July 15th? Does that count and cause you to not have to reduce your forgiveness?
It seems like, according to the language here and according to the guidance that we have now, that would work as long as you have them there before June 30th on the payroll, counted as a full-time equivalent, or at least their part-time hours add up to a full-time equivalent that replaces the ones that were let go pre-virus. I think that would work. There doesn't seem to be any test that you have to keep them for a certain period of time. So you might even be able to do it through just July 2nd or July 1st. We don't really know if there's going to be any limitations placed upon the length of time you have to keep them after June 30th, and there's none right now.
Alan, I do have a comment here. If you read the application and you follow the safe harbor math in the instructions, it seems to indicate that if you had exactly the same number of FTEs on February 15th as you did for the period February 15th to April 26th, you can't qualify for the safe harbor. And I'm not sure if that's a mistake or if that's literally correct, because what they're saying is you, in order to qualify for the June 30th safe harbor, you have to have a reduction in your FTE count from February 15th to April 26th. So it almost seems like if you're an employer that didn't change your FTE count in that period, in those 2 periods, you can't even use the safe harbor. Now, there's another safe harbor that says if you never reduced your employees or their pay, you're okay. But it's kind of interesting that if you let go of one FTE, or if you hired a new person in that February 15th to April 26th period, you technically don't qualify for the potential rehire or safe harbor, which seems odd to me.
Yeah, I hope they loosen that up. That doesn't make any sense.
Yeah.
Very interesting.
Yeah, so we have language here on how this calculated. I think the other nice thing that they did here is for this salary reduction, what we're doing is we're annualizing everything, comparing their annual salary and then prorating it back out to get the reduction during the 8 weeks. And for those hourly employees, we're just looking at the hourly wage and then prorating it again for the 8 weeks. So they don't have us comparing 8 weeks now to a prior quarter, which is 12, 13 weeks. They fixed that issue and gave us guidance on how we're making these calculations, which is here on these slides. Kevin, I'll let you talk a little bit about your expense calculator here.
And then we'll wrap up.
Yep.
Very good. The expense tracker is just a simple way for a company to keep track of the actual expenses, whether we prorate, whether we prepay. You could do both. You could do multiple different calculations. The one we've got on screen here is the older version. It doesn't have the alternate payroll period in it. Our version we issued yesterday does, because now you have two different measurement periods. And in our example that we published, we did the alternate just so you could see how it works. And you can see that the payroll that falls outside of the original 8-week period can still be counted. And what's important, I think, is for your business to measure both periods if you have the time and you have the internal fortitude to do it, because you really get to use the higher of the two. So you might have a prorated payroll in the original covered period that could be higher than the alternate covered period. I know a lot of people won't want to hassle with that, but that is something to kind of keep in mind.
So Kevin's spreadsheet's great. Here we have the information on how you can get access to the spreadsheet, which is being offered to sell through Lissy. We'll have a webinar on Thursday as well that goes through the spreadsheet and some of these issues in more detail. And then our webinar later today for Lineberg will also discuss a lot of this in a lot more detail as well.
Okay, Kevin, any last words for us? We really appreciate all the time. You've spent countless hours on this, and you've really mastered it like no one else we know. So thank you, but do you have any last words for us here?
Last word is the big word, documentation. Document everything. They gave us a gift, really, in the FTE calculation. Now we can fire. I've had people tell me, I can't fire a poor performer because I lose my FTE count. Well, yes, you can. Just document it, document it, document it. HR records are going to be important if somebody comes checking your FTE count.
Yeah, and your tracker has really nice documentation checklists that the client gets along with the calculations. So that's great. Oh, Kevin, my brother Randy is on the call. So he's always saying that you undercharge. Just so you know. And
yes,
I think most of the time you've spent on this tracker was really for him. So you ought to send him a nice bill. I would.
Yes, I will.
All right, for all you viewers, thank you so much for joining us. We welcome your questions, comments, and suggestions. You've got Kevin's email address as well. There, you can send the hard questions to Brandon and Kevin, send the easy ones to me. We'll be around to talk to you later this week, as we saw. Tell your neighbors and your friends and your enemies about us so that we can help as many people as we can. And may the rest of your day be billable. Thank you.